first of all, what is arbitration? What do we mean by that?
Sure. So arbitration is a process by which you surrender your right to have your lawsuit heard in front of a judge and a jury of your peers. And instead, your lawsuit is heard by a lawyer that is acting as a judge on your case. And when you agree to arbitration, you give up a lot of rights. The primary ones are you don't have people who have your sensibilities. You have a lawyer who looks at things very technically. You lose usually your right to appeal, meaning if that judge makes a mistake, there's no way you can change or undo it. And you also typically are going to lose your right to specific forms of damages or discovery that might be helpful to let you prove your case. Arbitration also has some strategic disadvantages for a plaintiff. Most plaintiffs don't file lawsuits more than 1 or 2 times in their lives. Nursing homes, on the other hand, get sued numerous times, and sometimes numerous times a year or even a month. And arbitrators are attorneys who are paid by the hour. So they have a strong incentive to build a relationship with the nursing home who's going to be a repeat customer and not necessarily with you as the plaintiff who they're likely to never see again. So arbitration agreements can be really detrimental to a plaintiff in the litigation context.
So, what is an arbitration clause in the context of an agreement with a nursing home? And, when can a nursing home kind of maybe slip an arbitration clause into something like an admission packet? And what are families really agreeing to in that case?
Arbitration clauses are just agreements to waive your right to a jury trial. And they are very often slipped into admission agreements or paperwork for nursing homes. A lot of times they're not even called out or discussed specifically. It'll be like a paragraph or a series of paragraphs within the admission agreement, sometimes with some bolded language, sometimes without. But what their purpose is to insulate the nursing home from potential liability if they make a mistake that causes an injury to your loved one. Nursing homes often are not going to single these agreements out. They try to kind of slip them in, kind of in the midst of all the paperwork you have to sign to authorize insurance and authorize them to provide care and sign the resident up for their room. And so you need to be very careful when you're reading paperwork. It helps to ask whether there is an arbitration agreement, and it helps to just at least scan, preferably actually read all the papers you're signing so that you know what you're agreeing to and you know if you're being asked to waive these important rights.
Can a facility make arbitration sound mandatory, that if a family does have to agree to this? And, what should families listen for when they're having that initial conversation with a nursing home?
So facilities should not make arbitration mandatory. And under Arizona guidance from the Arizona Attorney General, those arbitration clauses, particularly ones that require confidentiality or that the arbitration not be publicly disclosed, are often being attacked as not legal because they're mandatory and they require that kind of confidentiality. So you need to be aware if a facility is trying to suggest that an arbitration agreement is mandatory, you need to be aware that you can refuse to sign. And there are options you have, like going to the Arizona Attorney General and reporting that facility, that can help protect your rights. Similarly, when somebody suggests that an arbitration agreement is mandatory, a lot of times making a notation that you do not agree to that or that you're being forced into it can be very helpful later. That can be something as simple as writing "I disagree" or "refuse" over the arbitration wording, or just documenting your concern via a text message or a note after or during the agreement is signing, saying, "Hey, I'm not comfortable with this," and I told them I wasn't. Those things can be very helpful later if a lawyer needs to contest the validity of that agreement.
In many cases, putting a loved one, maybe a parent or something, into a nursing home is something that happens very quickly. Maybe they were in the hospital and then they're leaving the hospital. They have to go into a nursing home. They might sign an agreement like this under great stress, and then maybe now they're having second thoughts. What should a family do in that case?
So that is very common in the nursing home context, and it's important to be aware of what is going on. So if you are asked to sign an agreement and you think there might be an arbitration agreement there, or you're told there is, and you're told that it's mandatory, first of all, Some arbitration agreements do provide you the ability to withdraw. And so sending something to the nursing home in writing saying, I don't want to arbitrate my complaints with you, is an important first step. In addition to that, documenting what was going on at the time that you signed the agreement is very important. In Arizona, there are limits to the enforceability of these agreements based on whether you were coerced to sign them or not. And so documenting whether the patient was critically ill and needed medical care at the time, whether the facility told you that the arbitration agreement was mandatory for the patient to get care, how the facility described the agreement to you, and what they told you you were waiving are important factors for you to document. This is also a situation where you may want to think about recording the conversation you're having. Arizona is a one-party state, and so if you are talking to the nursing home and have the opportunity to record that conversation about arbitration agreements, that can be very helpful because nursing homes will typically tell courts or witnesses later that they fully describe these agreements to you, and having proof that that was not the case can be very helpful in overturning these agreements and allowing you to vindicate your rights in the state court before a jury.
And who should sign or maybe not sign an agreement when the resident lacks the capacity to do so?
So when a resident lacks capacity, they are going to need an authorized representative to sign for them. Capacity is a moment by moment thing in Arizona. So capacity is really defined as whether a patient knows where they are, what they're being asked to do, and what the consequences of that action are. And if you've got concerns about the capacity of a patient, then you probably shouldn't be having them sign agreements like this. What you should do instead is identify somebody who's an authorized representative. Typically, we do that through a power of attorney, which is a legal document that gives you authority to act on somebody's behalf. But there are also decision-making statutes in Arizona that can authorize you, if you are a spouse or a child who is the next of kin for this person, to act on their behalf. It's important to know that if you are asked to do that in a representative capacity, you should be particularly cautious about the rights of that individual that you're waiving. And you should be particularly cautious about whether you're being asked to sign optional agreements like consents or waivers that aren't necessary for the care that you're asking to receive.
If you do end up signing an arbitration agreement and that arbitration clause, does it really lock the patient and their family into arbitration, or do they have any other options?
So if the arbitration agreement is signed by the right person and in a situation that's not questionable, then you usually are going to be forced into arbitration for injuries to the person. There are exceptions to that rule, however. The biggest one in Arizona is that wrongful death claims are not covered by arbitration agreements. And so if you are a caregiver and your loved one actually dies or passes away in a nursing home, usually your claim is going to be for wrongful death, and that's not going to be covered under an arbitration agreement. There are also ways to try to get out of the agreements for injuries to a patient. Those include discussions about how the arbitration agreement was written and how it was presented to you. And those are the situations we talked about earlier where it's really important to get evidence that would support your claim that you were not told about the agreement or that it wasn't described to you in a way that helped you to understand the rights you were being asked to surrender.
Besides arbitration, are there any other admission paperwork traps that Arizona families should really slow down and review carefully before signing?
Yes, you should review the entire admission agreement. We are seeing a large increase in the number of facilities who are trying to ask patients to waive or agree to poor care in these nursing homes. For example, a few facilities have started asking patients to sign at admission things like fall waivers or pressure ulcer unavoidability documents. These are documents that ask a caregiver or a patient to agree that falls can't be prevented, or to agree that the care required to prevent a pressure ulcer may not be available in the facility. And then they ask the patient to basically recognize that risk and agree to stay in the nursing home anyway. While these are of questionable legality, they can be problems in the litigation context, and they can reflect poorly on the decision-making capacity of the people who sign it. So it's very important that you read these agreements and make especially sure that you're aware of what you're signing in these healthcare contexts.